Good afternoon, everyone. For those who haven't met me, my name is Tiffany Van Buren. I am the Deputy Director of the Berkeley Property Owners Association, and we thank you for being with us today. Before we get started, just a few housekeeping notes. Please keep your microphone muted unless you're called on to speak. If you're comfortable, we encourage you to keep your cameras on because it's more engaging for our speakers to know who they're talking to. And then you can submit questions either in the chat below or by raising your hand during the Q&A portion at the end of today's presentation. On the screen now is Paul Hitchcock. He manages educational outreach for Barth attorneys, and he will be keeping an eye on the chat and helping guide today's conversation. Speaker introductions. Today's session focuses on something every housing provider should be thinking about: liability, how it happens, how to prevent it, and how to protect yourself when things go wrong. We're thrilled to be joined by two highly experienced professionals: Steve Williams, a top landlord attorney who will walk us through common tenant issues and how to handle them strategically to maintain strong relationships and avoid unnecessary risk. And Brad Barth, one of California's leading asset protection attorneys, will show us where liability exposure often begins and share practical tools to shield your rental property and personal assets from potential lawsuits. You'll come away with real-world guidance that you can apply immediately, whether you're managing one unit or several. So let's get started. Please help me welcome Steve Williams, Brad Barth, and Paul Hitchcock.
Thank you. Yeah, thank you very much. Great to be here. We've given several talks for the group and really excited about this. And as we hand it over to Steve here in a second, I want to say a couple things. Is that we want to present this as an opportunity for you to ask questions. The more engagement, the better. These are two very busy attorneys who are here. You have 100% access to them. So each of them is going to give an initial breakdown on their area of expertise as it relates to you. And you can ask questions, in the chat. We'll get to those. We will have Q&A at the end, but just please take advantage of this. We love to give back and answer your questions. We also offer everybody who attends these seminars a chance to get one-on-one with Steve and or Brad for a complimentary call. That could be on a Zoom video, it can be on a phone call, and that can be, again, covering any issue you have with related to landlord issues, asset protection, even estate planning with Brad. And Brad, when he gets into his presentation, will show you how to get connected with us on that, and Steve will have his contact information up there as well. But take advantage of that. Those are great, 100% complimentary. Get one-on-one with Brad and or Steve and get feedback. And so with that, Steve, you want to take it up?
Sure. Let me just start by sharing my screen here. Hold on one moment. Okay, let's see here. Okay. There we go. All right, so everyone can hopefully see that. Yeah, great. Well, I'm glad to be here and give this talk. I've done this talk several times with both Brad and other members, attorneys of the firm. And we've got not a whole lot of time here, so I'm going to kind of breeze through these slides I've got here. So I'm going to be covering a lot pretty quickly. So definitely feel free to chime in with any questions in the chat there, and then Paul can stop me if I need to. But let's get rolling here. I'm going to just briefly talk about, or quickly talk about, common tenant lawsuits, sort of the ones that we're seeing these days, which are wrongful eviction lawsuits, breach of the warranty of habitability, very common now, illegal units, and the discrimination lawsuits. And then I'll briefly touch on insurance at the end. The first of the common tenant lawsuits is wrongful eviction. I think this is actually an appropriate place to start because here I mentioned any eviction in California, in Berkeley, or San Francisco, wherever you are, you need to comply with the just cause laws. And those just cause laws aren't, limited to just the Berkeleys of California anymore. It is statewide. So units all around the state are now subject to just cause, thanks to the Tenant Protection Act. And more specifically and locally, as pertains to you, as always, they've been subject to the very strict Berkeley eviction controls. And I mentioned this is appropriate right now because there was just a case that came down. It was just published out of Southern California, and it has landlord attorneys like me scrambling right now because it impacts non-payment rent notices. So you may want to take a look at that. I don't know, Tiffany, if you published anything on this yet, but it is the Eshagian versus Cepedas case, which says, hey, your non-payment rent notices now need to include certain information, which I think it's a bad decision. I don't think it's correct. But we have to deal with it. It is a Southern California decision that does not bind the judges up here. But as we've seen, the judges here typically tend to look and adopt what's been decided in other areas in California. And the main concern here is that you need to, in your notice, let the tenant know when they are served with the eviction, with the non-payment rent notice, so that they can calculate when it expires. Okay. So if they're being served, let's just say August 1st, the notice should somewhere reflect that they're being served August 1st, and then therefore the 3 days thereafter is calculated after that date. We're still, sort of working through as to how we're going to address this, but everyone needs to be aware that should probably talk to an attorney before serving a non-payment of rent notice right now.
Steve, can I interrupt? I'm sorry,
Sure.
but I just want to say, Krista, I'm getting an error message in the chat that says due to the large numbers, the system is not letting chat go out to everyone. I just sent one, so I don't know if anybody is going to be able to chat or not. I'd have no idea what's going on, but I thought I'd let you know.
Thank you. I'm not sure either, but we'll follow
Okay.
up on that one.
Okay.
Thank you.
I'll let you work on that, but just be aware that there are some changes, and you need to look closely at your notices to pay rent or quit. Okay, so the wrongful eviction lawsuits stem from evictions or that are wrongful or constructive that don't comply with state and local laws, such as just cause, and doesn't go through the normal channels of an unlawful detainer action. Got to avail yourself of all of that in order to evict someone in Berkeley and in California these days. Frequently, these cases allege negligence. The landlord acted negligently with the conduct or intentional conduct, that they intentionally tried to force us out. And of course, violation of applicable laws. The damages include lots of things like rent differential, emotional distress, out-of-pocket costs, treble damages, which means in Berkeley in particular, any damages that are proved can be tripled pursuant to the treble damages provision, plus potentially punitive damages, costs of lawsuit, attorney's fees. All those are part of damages that can accrue. Here's a case example. This was a new owner who purchased a building in Oakland. It was a multi-unit building, and without complying with just cause, just sort of started to bully his way around with a clear intent to drive the tenants out. At least that's what was alleged. Well, judgment following a jury trial amounted in $1.9 million in favor of the tenants. All right, but that's not it. The attorney's fees as well. Another over $800,000 in attorney's fees came to a total judgment amount. And this was just a couple years ago, over $2.7 million. So there's some real significant liability. Need to comply with the just cause and the laws, and definitely anytime you're endeavoring to recover possession of a unit in Berkeley or California anywhere, consult with a lawyer. Here are some ways to potentially avoid this. Familiarize yourself with the laws. Attending these regular meetings that BPOA puts on, great help. All right, and get a consult with a lawyer. Don't ever engage in self-help just because you think the tenancy's been terminated. And the tenant's not out. Don't go change their locks or put their stuff on the street. Can't do that. Got to go through the court process. Okay. Don't retaliate against the tenant for their conduct. Always be responsive to a tenant's complaint. Don't just brush it off. And of course, only evict with just cause. Again, sorry, I'm going a little quick here, but I want to get through here so Brad can give his part of the talk. So, all right. So another very typical type of a lawsuit these days, of course, the breach of the warranty of habitability. We all know that a landlord in California, it's implied in all residential rental tenancies that the landlord warrants that the unit is fit for habitability. This doesn't mean that it's perfectly aesthetically, perfect, but it does require some minimal standards. It's got to comply substantially with housing codes. All right. And here's a list of things. I'm not going to go through them all, but here's a list of some things. It's not exhaustive. These are just some identified items in the code, but it can certainly amount to other items as well. Just make sure to be responsive to tenant complaints, address them, and make sure the unit is habitable. Okay.
Steve, somebody said they missed what you said the SoCal judgment was. What was the judgment?
Oh, okay. This was back when I was talking about just cause and non-payment of rent. There's a Southern California case that just came down, Shagian versus Cepedas. Was published. It was a published decision, and it is outlining certain things that need to be included in a 3-day notice to pay rent or quit. Okay. And I would extrapolate that and say it should probably be included in other 3-day notices and maybe other termination notices as well. And the main thing is that the tenant needs to be able to determine from the notice exactly when it expires, basically calculate the expiration date. So if you say within 3 days it expires, well, within 3 days from when? Okay, you need to go that extra step now and probably say 3 days from when, or just state exactly when it expires. All right, so now here's a case example, a couple case examples. This one was, and again, these are ones that I've been involved with. This is one was asbestos was discovered during some construction work. The landlord here took immediate steps to remediate, but of course, the word asbestos, creates big alarms. It's a buzzword here. The tenants showed no adverse medical records or exposure, yet they, made a claim. In the second one, the landlord ignored repeated complaints from the tenant about mold. The tenant ended up suing. Both of these cases ended up settling with payouts of approximately $300,000 in each case. So again, potential significant liability when you don't, ensure that a unit is habitable and take reasonable steps to do so. So what are some ways to reduce that risk and handle this is include all your disclosures at the start of your tenancy, the rental agreement. Include your mold disclosure, your lead-based paint disclosure, your asbestos disclosure. Make sure you have language in there that tenants must maintain the unit in good and clean condition. Just use your standard rental agreement with all your disclosures. That's one. Be responsive to requests for repairs, okay? And this is big. Document everything in writing. The tenant, calls you and says, hey, I've got this. Okay, send an email or some sort of written communication. Hey, you just notified me of this on such and such date or such and such time. I will be over such and such time. Give proper notice to enter. Go over, take care of it. When it's done, send a follow-up. Again, paper trail so you can show how reasonably responsive you were. Okay, because believe it or not, this stuff gets misconstrued if you don't have a good paper trail. So always document everything in writing. And even with your, hey, look, I addressed this. Is there anything else? Are there any other issues? So you put the ball in the tenant's court, okay? All right, again, going through the lightning pace here. Illegal units. The term, okay, and again, this is a very common type of eviction, wrongful eviction lawsuit these days, or tenant liability lawsuit. The term illegal unit, it's really a misnomer. The unit itself isn't necessarily illegal. It's the use of the unit that's illegal. For instance, someone is renting it as a separate rental unit when they don't have a permit of occupancy. So it's that use. There's thousands of them in the Bay Area, and they're a very good source of housing and a very good source of additional income. But in California, it is illegal to enter into a contract, and a rental agreement is a contract, for an illegal purpose. Such contracts are void as a matter of public policy. But guess what? Though they're void, those tenancies, once the tenant's in place, are still protected under local and state rent and eviction control laws. So even though that contract may be void, the tenant's still there, and you still have to comply with all of your just cause requirements if you want to displace that tenant. So this is a significant source of landlord liability, because I say that these are fish in a barrel type lawsuits. Once you rent that unit, if the tenant sues, they've got a cause. They've got a cause against you. You've rented to them an illegal unit. Now it's just a matter of what are the damages. So what are some ways to potentially avoid these or minimize the risk? Is, well, don't rent them. Okay. I understand that's not possible. There's, like I said, there's so many of them, a great source of income, great source of housing. If you are going to rent them, just be aware of the risk. And I would disclose the fact that it's not a permitted unit. The reason is because doing that, and do it in writing, because doing that will at least reduce the likelihood of success on one type of cause of action I see in these types of lawsuit, which is misrepresentation. Hey, you misrepresented to me that I could, lawfully live here. Well, no, I didn't. There was no misrepresentation. So that at least potentially eliminates or reduces the potential liability under one cause of action. And always treat that unit as you would any other unit that's subject to rent and eviction controls. So make sure you comply with all of the local requirements. But if you rent these units, there is a potential risk. Okay. All right, discrimination. This is another big one. I'm seeing so many discrimination claims these days. A landlord generally cannot discriminate in housing at all against persons with protected characteristics. And the list of protected characteristics is very long, and it's growing, and it's really not exhaustive. Here I've got a whole bunch that you can see. I'm not going to go through all of them, but you can see there's at least, 20 characteristics right there that are protected. So virtually anything can be protected. Just, essentially, try to treat everyone similarly. These fair housing laws apply during all steps of housing, including the very initial stage of just listing the property and vetting prospective tenants. Those tenants get the benefits, those prospective tenants, potential tenants, get the benefit of fair housing protections as well. I'm particularly seeing this in these particular areas here. The protected characteristics such as service and emotional support animals, Section 8 tenancies, criminal background. These are all, in Berkeley now, these are all areas where there are some protections in place for tenants, and you cannot treat these people differently or discriminate against them with your tenancy or with the housing or even with listing or advertising units. And I'm seeing this particularly with tester groups. Okay, there are a lot of groups out there that are run solely to try to catch landlords marketing and advertising and vetting tenants in violation of fair housing laws. The recent one I saw was a tester group. Mind you, this is not a tenant. This is an organization that they hire people to follow up on, housing listings. And then once there's some adverse response, they go, aha, I got you. And they file a fair housing claim. That's what happened here. This was a recent case, a tester group based in New York, mind you, not even in California, based in New York. They had a tester call up my client. My client said, nope, I don't sign those government contracts. And they said, aha, we got you. Here's our fair housing claim. All right, what do you want to resolve this? Well, they wanted $150,000. Okay. And they weren't even the ones, again, who were rejected. They were a tester organization. So there are groups out there tasked solely with finding discrimination in housing listings. All right. So you need to be aware of that. And I see that a lot again with emotional support animals and particularly Section 8. Okay. You cannot refuse a Section 8 tenant or refuse to participate in the Section 8 program. All right, insurance. Now, I want to just, briefly hit on this before I hand it over to Brad. Let's see. Yeah, okay, good. And I think this is a good segue. What I, in addition to good practices and being aware of the laws and trying to be responsive to tenants and not cross the line with the laws as being a way to minimize your liability, here's a way to also minimize your own personal exposure or liability, and that's through insurance and maintaining a liability insurance policy that includes wrongful eviction coverage, okay? And I recommend at least $1 million liability, and that can be combined through the property policy uh, and an umbrella policy, or just the property policy. But a lot of times an umbrella policy can kick in to provide additional coverage. But it's important that both policies have the liability that includes coverage for wrongful eviction, and that the named insured under the policies is accurate. I see it all the time. An owner will change their title from themselves individually over to a trust or over to an LLC, and they forget to notify their insurance agent. So the policy remains in their names individually. Well, guess what? If there's a tenant lawsuit, the property owner, which is now the LLC or the trust, is going to be named. And if there's no coverage specifically named in the policy for those, either that trust or that LLC or entity, you may have some problems with your carrier. So always make sure that your coverage is up to date. And I'd go so far as to say, in the example of a trust, that Jane Doe as trustee of her trust is covered, okay, if that's the owner, and Jane Doe individually as an additional insured. Cover yourself both ways, because if the tenant sues, they're probably going to sue you both ways. Same thing with an LLC, ABC LLC. If that's the owner of the property, the policy should cover that LLC. Plus Jane Doe as member of that LLC. So plus Jane Doe individually, okay? If you can get that type of coverage as a named additional insured, I would strongly recommend trying to get that, okay?
Steve, Angelina's asking, does the court system know that the tester organizations exist and are acting in bad faith by making those calls?
Well, it's not really bad faith, but absolutely, yes. So tester organizations, that has been tested and in courts, and they are authorized. Okay, they can do that on behalf of or the benefit of the public. So yes, there are some cases that have challenged these tester organizations, and they're generally permitted to engage in that sort of business practice. All right. So with that said, again, I'm sorry I went so quickly here. Like I oftentimes give this talk over a good hour and get into some more details, but I just want to hit on some of this quickly, let you know sort of what I'm seeing as some main areas of liability and what you can do to try to minimize that liability. And now Brad here can fill us in on some additional steps that can be taken to hopefully reduce personal exposure liability.
Great, thanks, Steve. You want to hand over the reins there?
Yep. There we go.
All right, great. Now let me share my screen. Let's see here. Share screen. And let's see here. All right, great. Well, hello, everybody. And thank you very much once again for the organization to have us up here. And like Steve mentioned in his introduction, Steve and I and Paul frequently give these talks together. And what I like about it is that Steve kind of helps me present with you some of the sources of liability, some of the problems. And I love having a problem solution type of conversation. And
Yeah.
so Steve addressed some of the source, the problems. I'm going to come up with some of the solutions. But before I kind of get into my talk, I was taking some notes, Steve, as you were writing, and there was a couple of points I'd like to remind my clients. You basically said, get everything in writing, build a record. And I always tell my clients, you're not writing to the tenant, you're writing to the judge. So make sure you use the proper language, the proper tone. You said to be respectful, because ultimately the person who's going to read this file is going to be the court. So you always want to come across as the reasonable person, and as far as keeping things documented. So I think it's an excellent practice pointer as far as best practices. Write to the judge, not to the tenant. And Steve, you hit it at the last point there. The additional insureds, when we transfer properties into revocable trusts as part of their estate plans, into LLCs, family limited partnerships, always add on the additional insureds to make sure you're covered, because we have seen over the years, I've been at this for now 27 years myself, we have seen from time to time, especially now in California with the very aggressive stance that a lot of insurance companies are taking, they're looking for practically any excuse not to cover you. And they can come up and say, well, I see that you were covered under your own name, but you put it into an LLC or you put it into your family trust. The trust isn't covered and therefore you're not covered. So we think that almost raises the level of insurance bad faith, but it's very easily resolved just by adding the entity on the back end as an additional insured. I think it was excellent discussion points. So once again, so my part of the conversation here is kind of like some of the solutions. And I always talk with people when, especially dealing with real estate, is that real estate is unlike other types of investments. And you know, if you take $1 million and you put the $1 million in the bank, or you take $1 million and you buy a bunch of gold coins, the likelihood of the bank account or the gold coin suing you for liability purposes is relatively small, if not non-existent. But that's not what you did. You took the $1 million and instead you put it into a rental property or into an apartment building. And now that comes with it a lot more liability. It could be things that, as Steve had mentioned, habitability issues as far as how you're maintaining your property for the benefit of the tenants. It could be from things that are happening on the property itself, actions of the tenants themselves. It could be neighbors, common areas. So tenants come with, rental properties come with a whole lot of liability that can quite literally blindside you, even if you're doing the best that you can and trying to be the most reasonable and best landlord possible. It doesn't eliminate the risk of exposure that you have from creditors, predators, liens, judgment holders, and tenants. So understand the environment that you're investing in, and understand also that that there was a comment saying that, hey, there's a bunch of people out there, predatory, bad faith, coming after you. Is the law aware of this? And Steve said, yes, the law is aware of this, but you also have to understand that the same legal system that's facilitating this attack against you, the landlord, is also the same.
I'm going to go to Walmart. I'm going to pick up one of those sour.
We got to mute people here.
Okay, so
Well, you're going to have the rest of the
okay, so let's see if we can get them
meatloaf. I'm going to have mashed potatoes.
This is much more entertaining than my talk, by the way.
Just going to have mashed potatoes.
We know they're going to Walmart.
Bread.
Hey,
Have a meatloaf for dinner.
Tiffany, can you
All right.
mute? Can you mute?
So
All right.
what my last point here was, before I kind of get started, is that the same legal system that enables these predators that come after you, that the have-nots that come after the haves, is the exact same legal system that gives us the tools and the techniques that we can defend ourselves, to give us financial self-defense. So understand the environment that you're working within. Go in it with eyes wide open and insulate yourself by building up some of these asset protection fortresses. Steve already brought up some of the sources of liabilities. I'm going to come up with some of the solutions. And a lot of this isn't going to be anything new. It's just a matter of awareness and maybe a little nuance here or there that you can add to your order to your knowledge base. So this is a talk about protective legal structures for property owners. And as I was already introduced by Tiffany and by Paul, I'm Brad Barth, a partner of the firm of Barth Calderon. We're located down in Orange, California. So we already mentioned some of the risks that we face, and we're aware of these: slips, falls, fires, habitability, dog bites, electrocution, lead paint, mold, asbestos was mentioned during the talk. So these are just the sources of liabilities. I'm sure all of you are already aware of these. One thing you also have to be aware of is something called in California, it's now called a Avoidable Transaction Act. Because what happens is that sometimes people will hear a talk like this and say, oh, I have a liability. Oh, I'm involved in a lawsuit. Then they call me and say, what can we do now? And you have to be aware that any kind of limited liability tool, like transfers to trusts, transfers to LLCs, these transfers, if they come post judgment or they come after you've been sued, they get looked at with a high degree of scrutiny, because there's some things that you can do before an action arises that may not be available after an action arises, because it's very simple. If you get involved in a lawsuit and you try to transfer assets away, to move assets out of the hot zone, you're basically trying to hinder, delay, or somehow defeat a creditor's claim. Well, there's a remedy on board for a plaintiff saying, Your Honor, Paul is just trying to move his assets away so I can't collect when I finally get my judgment against him. That's called a voidable transaction here in California. In other parts of the country, it's called a fraudulent transfer or fraudulent conveyance. Basically, something arises, you're moving assets out into trusts, into LLCs, you're giving it to Uncle Bob, you're giving it to your kids, all as a way to protect the assets from foreclosure or satisfaction. And there's actually a remedy for that. So we want to do this beforehand, just like any other kind of insurance, medical insurance, auto insurance, homeowner liability policies. You want to have these tools in place before the event arises. It's not to say that you can't do something once something happens. The level of scrutiny and the level of toxicity that you become to us trying to facilitate a transfer for you varies dramatically based upon the timeline. So it's like anything else in life, you want to be proactive rather than reactive. You want to have these tools in place before you need it. And you can see my last little quote down there: asset protection planning is just another form of legal risk insurance. You want it done before before the event arises. Now, Steve already mentioned this, and I'm sure all of you are aware that insurance is always the number one tool that people turn to. You get into a car accident, it's auto insurance or an umbrella, commercial liability, property and casualty, malpractice, E&O, D&O, renter issues. Of course, you want to have insurance in place. How much insurance? That all depends on what the activities are. What's being protected. Should I have too much insurance? What if I don't have enough insurance? I always say you want to have that Goldilocks zone, not too hot, not too little, not too cold, just right. And what is that just right? That's with you working with your insurance professional, finding out what's the right amount of coverage for the activities that you're engaged in. Again, you don't need $10 million of commercial if you really only have $5 million at potential loss. Again, working with your professional to get that done, because again, insurance is a very important part, and everything that I'm talking about is not done to the exclusion of insurance. It's in addition to insurance. Our objective is, I got sued, I got into trouble for whatever reason, take the insurance company's money and leave my personal assets alone. That's why you have insurance. The idea is you got to have it. The question is, you want to have the right amount, that Goldilocks zone amount. But on the flip side, you always have to be worried about the exclusions or insufficiencies of coverages of insurance. So insurance is necessary, but insurance alone is not an asset protection plan. One reason, as you see the first line item there, is exclusions. If you're doing something or there's activities on the land, Steve, you mentioned illegal units. Maybe that's specifically excluded from the policy. You could have a great policy, but guess what? Because you're engaged in the illegal activity, that may be excluded. Yes, they may have the illegal habitants may have all the rights of a tenant in California, but you don't have coverage because that act was excluded. So you got to be very careful that you can have a false sense of security thinking that you have insurance or you have adequate insurance when in fact you don't. And when you don't have insurance, you gotta have a fallback plan. So when insurance is not there, you gotta have that next rampart, that next layer of defense. And that's where the trusts and the entities kind of come in. Like I said, it's not to the exclusion of other planning, it's including other planning. So here again, one of the main tools that we use, again, this is nothing new to all of you online here, is the use of LLCs, limited liability companies. Those two kind of LLCs and real estate and rental properties go together like ham and eggs. They're married to each other. Just perfect. They're perfect tools for each other. And as you can see here on my little diagram, infographic here, you just have a couple of an LLC here is the green oval, and some here a client has two particular pieces of property in there. You got a square and you got a rectangle. You got a house and you got a apartment complex. So those are the assets that are inside. But when it comes to LLCs, you also have two people that are involved, and many times it's the same person. The person inside the oval, inside the LLC, getting involved in the day in and day out operations, manager. That's probably you. Or maybe you hired a management company and they're kind of helping you with some of these daily activities and operations and ongoing activities. Then there's you. You're the owner. And when dealing with LLCs, you're called a member. A lot of people may confuse the word shareholder. That's more reserved for the corporations. That's how you identify a corporation owner, as a shareholder. In LLC land, you're referred to as a member. So here we have a manager managed LLC. That's kind of your parties here. But when you have entities, especially when it comes to real estate, you got to worry about somebody on the inside. You got the slip and fall tenant, you got the fire, the dog bite, the habitability issue, the discrimination problems that Steve was talking about. And now they go off and hire a lawyer and they're suing you. They don't sue you. They sue the entity, right? They sue the entity, and everything that's inside that entity is now subject to satisfaction for that particular claim. Because sometimes I get pushback saying, Brad, I hear what you're saying. I understand what you're talking about as far as asset protection. We already have an LLC. And I ask you, well, what's in there? I got 15 pieces of property. I have 15 apartment buildings inside my LLC. Great. Here's the problem. When someone slips and falls on one of the apartment complexes or one of the locations, again, dog bite, fires, common area problems, make it up. You guys know what the risks are. That tenant, that liability is now inside the box. The fox is in the hen house, and they start going after all the assets on the inside. And if that first asset wasn't sufficient to satisfy the claim of that particular judgment, they'll go after the next one. And if that wasn't enough, they go after the next one and the next one and the next one. Because although you have an LLC, which may be the right tool, you haven't diversified the holdings within. And not all properties have the same risk profiles. So they're not really good to mix them in the same bag. What do I mean by that? You have a single family home. A single family home has behind a gated community has a much lower risk profile than a 20-unit apartment complex or a fourplex that has 8 souls on there, or the location. Maybe you have a lower socioeconomic neighborhood that some things are involved in, or you got college kids and condos and drinking going on. So each property has to be looked at from its own risk profile, and you don't want to mix high risk assets with low risk assets. You don't take the commercial building that you earn a living from as your own owner occupied tenant, and you put a tenant in your rental property inside the same entity because you didn't want to pay California $800 times 2. And next thing you know, you get the slip and fall on the rental property, and you're now don't have a place to earn a living because they took away your commercial building. And they were able to do that because you put all your eggs into one basket. So one of the things that we try to do is to diversify. Yes, you had your own limited liability, but you lost everything that was inside there. So you got too many eggs in one basket. So what we want to do is break these apart. Is there a way based upon income flow, based upon equity in the investment, based upon cash flow, based upon risk profile, based upon the number of souls or doors occupying that location, where now we want to diversify, not just having one LLC, maybe having 2 LLCs, maybe having 3, maybe having 4, maybe having 10. It all depends. And these are not cost prohibitive. When we come up and working with our clients to find the right mix of entities, we are taking into consideration the cost of the structures. I speak nationally, and I can tell you that California is one of the most expensive places to maintain an LLC. And $800 minimum franchise tax fees with the gross revenues of $250 or less. You add more than $250, it's another $900 on top of that. So I understand that there's costs associated with that, but also remember that these costs are 100% deductible against the income. So you got to factor that in. And if you have $1 million property in here and you're concerned about $500 net of taxes to maintain a structure to protect your entire investment and to protect you personally, that's not good business practice. It doesn't make sense. So a lot of what I do in the counseling of my clients is help them come up with a good architecture of structure, but also get them in the right mindset as to why they're doing this and why this is a good use of money. So in our previous example, you had one LLC, 2 properties, 1 liability, but they lost everything. Here, just by breaking it apart, you got the same liability inside LLC 1, but guess what? LLC 2 is completely safe because it's isolated and insulated from the acts of LLC 1. Now, on top of that, this is an example of liability risk management. We're worried about protecting ourselves from the internal risks of the tenants, right? Limiting liability. But wait a second, there's 2 sides of that coin. And the other side of that coin is, wait a second, these are also my assets. I'm depending upon them for cash flow for my retirement and my living expenses. I'm depending upon deductions on taxes. I'm depending upon a future appreciation and power to sell for whatever. I want my kids to be able to occupy it later. So now you have assets. So now you have limited liability and asset protection. So that's why I call on the red line there dual protection. LLCs set up correctly offer dual protection, limited liability and asset protection, but not all states are created equally when it comes to the asset protection side of things, especially if you're a single owner of an LLC, or maybe you're a husband and wife in a community property state like California. Sometimes we don't really have the asset protection because your personal creditors can reach in and foreclose on those assets. I like to give my clients a very good example. I learned it when I was in elementary school. It's the story of the 3 little pigs. And we all know about the 3 little pigs. You got the big bad wolf is chasing them. And what do? They first run into a house of straw. And the big bad wolf huffs and puffs and blows the house down and eats the little piggy. Our case, they grab your property, right? Then they run over to the house of sticks. And the big bad wolf huffs and puffs and blows down the house of sticks and eats a little piggy. But then they go over to the house of bricks. And the big bad wolf is huffing and puffing, but he cannot blow the house down because the building material that they used for that particular fortress was stronger than straw. It was stronger than sticks. It was made of a house of bricks. And so what we do when we design our client's asset protection structure, and our big bad wolf is that little guy on the bottom of the slide with his hand out, that's Mr. Wolf. We want to make sure that they're unable to get in to our clients' assets, our little piggies, and we do that by using other states. And you've heard about this. Why do people create Delaware LLCs? Why do you create Nevada LLCs? Why are they in Wyoming? Why are they in South Dakota? Why are they in Alaska? Why are they in these other states? Because they're using bricks as their building material, not sticks and not straw. So you'll see an example of a very simple client here, Apartment Holdings LLC, a Delaware LLC authorized in California. Their dirt is in California. The apartment is in California. You're not getting around California. We're just using Delaware brick building material, not California straw building material. And same thing with their townhouse. Nevada, brick material authorized in California because the dirt is in California. The operations are in California. You, the brains, the nerve center are in California. So this
Brad, what someone's asking about holding the title in a family limited partnership and charging orders and so forth related to that. I thought
it all depends again on the jurisdiction. Family limited partnerships and LLCs, the charging order is the same. It's the same exact concept, and not in all states treated a little bit differently. You got again, bricks, sticks, and straws. And that also depends upon who the limited partners are, right? Disinterested, husband and wife, all that makes a difference. So yes, sometimes limited partnerships are fine as they are. Sometimes a tweaking in the jurisdiction has nothing more than say, I want to use brick building material, not stick or straw material. And that's very important. It's a good, great question. Come across it all the time, but that's the important takeaway. Why do they use different jurisdictions? Let's see, where are we on time? Okay, great. So now getting beyond our investment properties, what about residences? Again, coming back to our personal assets, sources of liabilities, not just arising up from tenants. What about just like driving your car, right? You get into a car accident. Well, you didn't get into an accident. Your spouse got into an accident. And again, in California, that's a community liability that can be satisfied by community assets. One such asset is our house. So can they come over and take your home away from you? And again, depending upon the amount of equity in your home, this is the current law. It's called a California homestead exemption. These in a homestead exemption basically says how much of the equity are you guaranteed to get back if the big bad wolf comes and tries to gobble up your home. Now, back in 2020, Gavin Newsom updated the law to all of our favors. And you'll see there's now a floor and a ceiling. It used to be only 100,000, 150,000 homestead exemption, which was de minimis relative to the property values here in California. So the assembly went to work, and in 2020, they kind of updated the numbers a little bit more realistic, where at the time the floor was 300,000 and the ceiling was 600,000, being indexed for inflation. And I put down below on the slide here your 2025 statewide amounts. So your floor is now about 361,000, and your ceiling now is about 722,000. So if you have more equity, and again, that number, where do you fall? What was the average sales price of a home in your area? Call it your zip code, your area, the last 12 months, right? The last fiscal year. So they take an average sales price of your home, and that would be and where are you falling between that indexed number? And that would be the amount of homestead exempt that you have. Max 722, lowest 361. And
Brett.
why that's important. One second, Paul. And why that's important. I just got off a call with a client of mine who had $2.5 million of equity in his home, and he was in a high value area. So the 722 wasn't sufficient. He still had an exposure of $1.3 million of equity in his home that we had to deal with. So the homestead is good, but you got to factor that in the other items. Yes, Paul.
Yeah, so just to follow on, and then a new question, what about a flip in California? And then the other question is, what are the income tax implications of having an LLC in another state?
Okay, so the income taxes are a non-issue because all your taxes are a result of where you are as a resident, where you reside. So although you have let's say a Nevada LLC authorized in California, and you have some income coming off of that, either K1s or 1099s or nothing, because it's all flow through, everything winds up on your 1040. The only thing you'd have to file in these other states is to keep the entity alive, which would be in Nevada, $350 with their Secretary of State, and maybe $150 for a registered agent. So
a year.
That's right. Again, 100% deductible as part of the operating expenses of the entity. So there's no taxes due in those states. It all flows through to your 1040. So all these different building blocks that we create are not for income tax purposes. They may have some estate tax benefits as far as building for fractionalized discounting and things and gifting, but basically they're conduit or flow through or tax neutral for income tax purposes. Okay, so that's that. All right.
All right, and the flip in California, and then there's another one, is the homestead exemption automatic, or do you need to do a form or something?
Yeah, there's normally a form. There's typically a form. I would make sure you file the form. Yeah, that's form. Then what was the flip question? Was that
just to follow on when you were talking about flips and asset protection, they said, what about a flip in California?
So again, depends upon who the underlying members are, because again, charging orders do apply to family limited partnerships. And again, depending upon who the limited partners are, it may be okay as it is. Again, I'm not saying that California is no good for nothing. It just, again, everything has to be looked at and scrutinized on the individual basis. All right. Okay. So so basically that was the homestead exemption. And so some of the things that we do for our clients is that we say, well, can we put a wrapper around our house similar to how we put a wrapper around our rental properties? And the answer is yes, but it needs to be done in kind of a specialized way. And the reason why it needs to be done in a specialized way is because of how it's characterized. Rental properties and LLCs it's understood that these are investment properties, but your residence in an LLC is not an investment property. It's not a business, it's your residence. And there are certain tax advantages that the government gives us to encourage home ownership. Mortgage interest deductions, SALT deductions, 250,000 per person capital gain exclusions, credits for putting solar panels on and stuff. So there are certain very specific tax benefits to being a residence. If you take your residence and drop it inside an entity like an LLC, now you've changed the character of that property from residential to investment, and some of those tax benefits may go away. So there is a way we do, and some of you online may have heard of a concept called the use of a land trust. A land trust coupled with an asset protection oriented LLC, that's how we do it. We use the land trust as a conduit, so we're able to maintain the residential characterization of the property, but yet still put a protective LLC around it. And then one of the added benefits that we do is privacy. We have privacy for a lot of our clients, especially those of you who are involved in real estate. A lot of my clients want to know, how do I go incognito? I don't want my tenants showing up at my house at 3 o'clock in the morning telling me to fix the toilet for the 10th time, 100th time. They're harassing me. So how do you go incognito? So we design entities in jurisdictions that put nominee arrangements on there. We use virtual mailboxes, so you're able to have your mail, but not your home address. So there are ways that we use nominee managers, nominee trustees to create privacy. Nothing to do with loss of control, nothing to do with loss of the income flow. It's all nominee arrangements, and therefore it's very important for you to kind of go off the radar for purposes of dealing with the public, including your tenants. So this is one of the vehicles where we're able to put in a privacy element to your overall structure.
What if they live in their fourplex?
That's a little bit more challenging, because you don't, when you put properties inside because it's difficult, because you don't say 3 of the 4 units I'm putting in an LLC and not the one, because you put the parcel in, the entire AP, the parcel goes in there. You're moving the dirt, and then the fixture, which is the building itself, goes with it. You're not moving the building, you're moving the land. And when everything attached to the land, the fixtures go with it. So when you're an owner occupied of one of your own places, this type of tool I have on here is probably your best bet, but you still have some internal liability to be addressed. And this is where maybe some proper insurance can kind of come in and really help us out. But let me just kind of wrap up here in the last couple minutes that I have. Again, this is just the use of what are called a spousal lifetime access trust. I'm not going to spend time on it now, but I want to just drop the idea. We're currently in an estate environment where each of us has a $13.99 million exemption. And if you're married, you double that up to about $28 million. Just over the holiday weekend, President Trump signed in the One Big Beautiful Bill, which raised that exemption to $15 million per person. So it's going from 14 to 15 million. So $30 million for a married couple. This is very important because it's unprecedented in the history of the country that our state exemptions are so high. And we have to worry about what happens with the next administration. We weren't sure if Trump was going to be able to get this, and we were going to sunset from a $14 million exemption back to the Obama numbers at a $7 million exemption. And why this is important is because a lot of my property owners have high net values, high estate values. They may be cash poor, but they're chock loaded in value of real estate, which is giving them a taxable estate. So how do we get these assets out of their estates before the estate taxes kick in, or before the next administration reduces the dollar amounts? And a SLAT, spousal lifetime access trust, really seems to be the silver bullet we've been using the last handful of years. Again, beyond today, but for those of you that have heard about this, we can definitely address those high net worth clientele base. and just kind of showing you how it all kind of interacts with each other. Here you just have a client that has like their family trust. You mentioned earlier, Paul, about trusts. Here you have your rental properties, business properties, and then here you have like your commercial building maybe over here in its own LLC, separate from the operating company. Then they have a couple of single family homes, single family home 1, single family home 2. Then they have a spousal lifetime access trust. The idea here is that all these are properly structured within the proper tier of their plan, and you can see OpCo separate from commercial holdings, separate from their IP holdings, separate from single family housing 1, 2, and other things. So you can see that the idea is it's not just, oh, I have a corporation, or oh, I have an LLC, or oh, I have a family limited partnership. No, you got to look in and see, can we further diversify within? All right, so it's going to kind of wrap it up as I promised, and Paul had mentioned. Here's the text. If you want to text this number, 650-459-2712, you text the word guard assets. That will go straight to Paul, and then Paul can help to get you on either my calendar or Steve's calendar, and that's probably the easiest and best way to get directly in contact with both Steve and myself. So I'll hand it back over to you, Tiffany. Thank you very much.
Thank you, Brad, and thank you, Steve, if you're still around. Did we have time for a couple of quick questions?
Yep, I'm good. How do I turn
I'm around.
get you back on? Did we stop sharing? Yes.
Yeah, you can stop screen
Okay.
sharing.
I did or did not?
You did
No,
not.
you're still up. That's why you're
Okay.
that's
Yeah,
why
I
you're
know.
not
I'm
seeing
trying
the
to find out
room.
where's the gizmo here for stopping this screen share. Oh, there it is. Stop share. Got it. Okay. Better lawyer than computer technician. Okay.
Oh, there you are, Steve. Yeah. All right. Does anybody have a question to ask our panel?
I've got a few. If just I want to address that came up. If would love to have any
Sure.
from the audience there, but can I just expand on a couple things? One, oh, there's a question. Do you do living trusts?
Yes.
The answer is yes. If you email me, fill out the text guard assets, the trust, you can get one-on-one for complimentary assessment with Brad to talk about that for sure. Steve, I know you brought up before, you had a mold case, Steve, that the landlord fought it. There was mold or something, but the landlord fought it and lost, and it was a very expensive judgment against the landlord. Just a quick response from you. What do you advise a landlord to do if there is mold? Like, how do you handle that? What's the best practice?
Yeah, so, well, first of all, there was a recent law change. Well, I say recent, within the last 7 or 8 years, where the laws now do put some responsibility on tenants to ensure mold does not grow in certain areas. So in areas of a unit where there's, regular moisture, like around showers, sinks, bathrooms, in those areas, tenants are required to regularly wipe them down, any surface mold, clean it, properly ventilate, and just take steps to do things to prevent the mold growth from growing, from getting more pervasive. What I would recommend in those situations, and I'll have clients come to me and say, "Hey, I just got this complaint. This is all the tenant's responsibility. I'm going to let them deal with it." Well, I generally recommend address the problem first and point fingers later. Don't just turn a blind eye and assume it's the tenant's responsibility. Well, it very well may be. Just get before it grows into something worse, before before the tenant starts complaining about health problems, get it taken care of. Talk with your remediation company to find out what was the source, what was the problem. If it was the tenant's fault, then you either reprimand or potentially even hold the tenant responsible for the cost of cleaning up. But always get out in front of it and eliminate it, reduce it first, and then deal with responsibility later. And so just in general, anytime you get that complaint about mold, just get out there right away and let the professionals handle it, remediate it in accordance with the plan set forth by the professional.
Okay, and Brad, I had a question for you on the LLC because it's top of mind. So I tell everybody we get about 10 hair on fire calls a week from people who have liability going on, and they're nervous. And this week alone, because a lot of it comes into me, and I see it. But this week alone, it was somebody who a realtor that got sued, sold $1 million home. I live in Marin County, and it was over here. So sold a very expensive home, floors buckled. They had a personal lawsuit against the realtor and against her husband, who had his own business. Brad, this is an outside liability.
Mhm.
And so they were going after everything. They had rental property in San Francisco. They had a stocks, bonds, and cash account, and it was full force attack on something unrelated to the rental property. But Brad, so what would happen? So as they go after this person, is someone getting, if you have an LLC and it wasn't done right, is it going to be attacked and fall apart?
Yeah, and I think that's one of the big differences between working with someone that specializes in these areas as opposed to using some of the free online services that you not free, but the online services. Because it's not you got a combination. It's a what do you call it? It's a belt and suspenders approach, right? The first thing is you want the operating agreement, which is the personal constitution, the governing documents of the entity, to be as protective as possible for whichever direction you're going for, limited liability or asset protection. So you want to make sure you have all the necessary poison pills in there to protect the target, whether it's the inside or the outside. That's one side. But as I mentioned, Paul, the other side is what state are we looking at? Now you also can lean on state law. And then that's based upon statutes, and then the precedent that's been put on that statutes by case law, and how that's been kind of unfolding. So it makes a huge difference whether you're using an online service, whether you're using your you're using your whatever your attorney that does intellectual property to put together your LLC. They're not the same. Our just again, just this by side comment, I've been at this for 27 years, and my agreements have, I think I'm on like version 300 of my operating agreement, because we're constantly updating it with language based upon case law, based upon changes in statutes, based upon our own client interactions. So they don't get, they can get stale. And you always want to make sure you have the latest and greatest, just like any other living document. You want it to be the best. But to answer your question, it's a belt and suspenders approach. You're not just relying on, oh, I have an LLC. You want to, okay, what are the terms? What are the vulnerabilities? What are the strengths? And then what laws are you using to benefit you? And I believe Richard has his hand up.
Yeah, and I'll tell you, just before we get to Richard, I'll just say that, and I can get this out to Tiffany for distribution, but we did a recording not long ago with Brad's father, the founder of the firm, Harry Barth, and Martin Greenbaum, who has one of the largest collection law firms, around. And Martin's the guy that if someone's got a judgment, you give it to Martin and he will attack. And they're friends with each other, Harry and Martin, but Martin went through, this is how I get your money. And he went through how he picks apart your LLC, how he even gets into your retirement plans, he gets into your home, your bank account. And it was eye-opening, because you think you're safe. If your LLC has a crack anywhere, lousy operating agreement, or you don't have one, you're commingling, a guy like Martin or one of his attorneys is going to tear that thing down. So very important. And we have a couple questions. Richard, you want to ask something?
Sure, I've got two questions, an insurance question and an eviction question. Okay, the insurance question is regarding a limited partnership. So I'm the employee of the general partner. A few of the limited partners, or a couple limited partners, have requested to be added as additional insureds on the policy. I've spoken with our insurance agent, experienced insurance firm, been around for decades, represented us for decades. He says, no, you don't add a limited partner as an additional insured because they are primarily insured because of the insurance we have for the limited partnership. So I was a little bit thrown by the business about adding individuals as additional insured in LLCs and wondered how that applied to another entity such as a limited partnership.
Well, I'll take a stab at this one. I would agree with your insurance professional that a limited partner probably does not need to be added as as an additional insured. They already have limited liability just by being a limited partner. I would be more worried where you're standing, Richard, as part of the general partner, because you're the one that has the exposure. The GPs have unlimited liability, whereas the limited partners have limited liability. So, and I would just think make sure that you have a good a good insurance policy, that the limited partnership is added on, the company's added on additional insured, and you guys have good E&O and D&O insurance for your side. And then just for time purposes, let's go on. Any other questions, Paul? Address that, Richard, if you want to give me a
Richard,
talk
yeah,
about it. Yeah.
I think Richard actually froze there. Oh, go ahead, Richard.
Feedback.
Yeah, okay, if I asked my my second question.
Oh, sorry, there's a second.
So a tenant in a building has requested a buyout. This is in Berkeley. Of course, I told the resident manager, don't say a word before you give them the notice about buyout. They sign it, you sign it, blah, blah, blah. They say, we can't afford to be here anymore. We want to move out. There's a good amount of back rent, but we also want $5,000. So before I go into an attorney's office, and maybe one of you fellows in Berkeley or in the East Bay, what would I need to bring with me besides the rental history of this apartment and this tenant? And first thing, of course, we're checking on, and I've said, make sure there are no habitability issues. There have been no requests for any service, and we're going to confirm that. But is there anything else that I would need to bring to the office for a first consult?
So when I do buyouts, I generally want to see a copy of the rental agreement, like you suggested. I want to know the names of everyone who's living there. I want to see a copy of the deed, so I know exactly how title is held and who the parties to the agreement are going to be. And I also like to see the insurance policy to make sure that you are covered for wrongful eviction. That's what my office generally wants to see. And depending on the circumstances and what you tell me, there may be additional items I'd want to see, but those are the things that I initially want to see.
Thank you, Stephen.
Yeah, and we've got if I use Zen Business, create an LLC, would I then need to consult with an attorney to transfer the rental properties into the LLC?
No, you don't need to have an attorney do that for you. Really, all you need to do is get the deed. You got to deed the property in. The challenge is that not a lot of people are familiar with how to transfer real property into entities, and doing it in such a way that won't trigger a Prop 13 reassessment. That's one thing. Then you have some of the other housekeeping items that go along with that. Besides just moving the property, you also want to do assignments of lease agreements. So we've already talked about the insurance policies and putting on as additional insureds. You also want to have bank accounts being done, and then just maybe a little housekeeping and education about operations now that you're operating your business through the LLC. So you don't need an attorney to do that at all. It's just that most people are, although they can get a bank account set up, they can work with their insurance person on the insurance side, they don't know how to put a deed together. So I think that would just be a good use of money for a few $100s to make sure you get the deed inside.
Steve, someone's asking, can I clean up the mold tenants are complaining about, or do I have to engage a remediation firm?
Really, it depends. It depends on how pervasive it is. A lot of mold is just surface mold. You just wipe it, clean it up. But where it gets more tricky, and you may not be able to tell, but where it gets more tricky is if there is like a water leak and some other additional repairs need to be made, and there actually may be mold inside the walls or under the tiles or behind tiles or things like that. That's where it gets a little more tricky. So unless it is, clearly mold from, like where I'll see it sometimes is, behind an item that's pressed against a wall for a long period of time, you pull it out and you see some mold growth along the wall right there where it was pressed against the wall because there's no circulation. In that scenario, that's probably pretty obvious, just surface mold. But if you have it growing in an area where it's not quite so evident, you may want to get a professional in to take a look at it.
Thank you,
Okay.
Stephen.
Tiffany, I think we're good.
I think we are too. So thank you so much, Brad, Paul, and Stephen, for being with us today. We always appreciate your sharing your expertise with us. And for anyone who came in late, this recording will be available in our newly improved Knowledge Hub under risk and asset protection. And it'll be some other places too, but that's the best way to find it. So thank you. I'm sure we will see you again soon. And hey, did you want to quickly, Paul, put that back in the chat for people to screenshot the text number with the code?
Yeah, Brad, do you have that up?
Yes, I do. I have it right here. Let me.
Thank you. Sorry. Yeah.
Paul, I have to share the screen. You want me to share the screen just for a
Yeah.
moment?
If you just show that real quick. Yeah, I did put my email in the chat. People can email me if you have one question or you want to get with Brad. But also you can get a Zoom with Brad and Steve by just go to your mobile phone and you text the word guard assets to the number Brad's going to show you. So just text guard assets like you're texting, text it to that number, type in that number, and what you'll get is a quick form. Just put your name on there, send it in, I'll get it, I'll get you booked. And again, this is just complimentary. It's not a sales pitch thing. It's just we want to give back value to anybody that takes the time to hear us. You get on there, ask away. Estate planning, asset protection will give you any sort of input, and also get you connected to our blog, which goes out weekly, where we're guiding, teaching, helping property owners on really good information. So you can also just get signed up for that by texting guard assets to that number.
Fantastic suggestions. Take advantage, folks. All right, everyone. Well, thank you again for attending, and we'll see you next time.
Okay.
Bye-bye.
Thank you,
very much.
Tiffany. Okay.
You're welcome.
All right.
Bye-bye.